Welcome to the Legal Zone. I'm attorney Marcia Mignot. Today we're going to cover the subject of what you do if you are served with divorce papers. Now, remember to check your local attorneys in the state you're located in to determine what the law is as it pertains to divorces in your state. But as it pertains to the state of Georgia, if you are served with divorce papers, you have 30 days from the date you've been served with those documents to file an answer. If you do not file an answer, you are subject to not receiving notices as it pertains to the divorce case, and a divorce still can proceed without your presence at the court. Keep in mind that once you're served, you cannot start depleting assets. Do not go out and start transferring assets into someone else's name, because that is going to infuriate the court, and the court is going to be upset and they can still reach those assets. So transferring bank accounts, taking cash out and transferring it into other individuals' names and giving it away so that it can't be divided with you and your spouse, that is improper. Now, once you've been served, you file your answer, and the court is going to schedule what's called a temporary hearing. Once a temporary hearing is scheduled, the court issues a temporary order in the divorce to determine what should happen temporarily until the parties can come back to court at a final hearing to make a determination as to what and who should get what assets. If your divorce pertains to adultery, do not panic. Keep in mind that if you've been served with the documents and a person who is alleging, the plaintiff, that you are committing adultery merely because you had lunch with someone, that's insufficient to prove adultery. There has to be way more things like at birth of a child for the individual or birth of a child outside of the marriage. Those are all things court will consider. Now in Georgia's a no-fault state as it pertains to divorces. So the court does not care who's at fault. All the judge needs to know is that one of you, the plaintiff or the defendant, wants a divorce. And if you've been served and you're the defendant, that means your spouse is seeking a divorce against you. Now, when you get to court, the judge is going to want to know from you what you're seeking temporarily. So you have two options. You can represent yourself when you go into court. You could say, Judge, I have nothing. I don't care. I'll take a divorce. There's nothing to be divided. There are no children as this relationship exists, and there are none expected. So I don't care, Judge. I'll take my divorce. That's an easy divorce. Those are usually considered uncontested divorce. Where divorces become complicated and expensive is when you're the defendant in a divorce where there's a lot of assets. You make a lot of money. You all have a lot of houses, or you have vacation homes, there's expensive cars, and there's a lot of child support to be obtained based on the fact that your income is substantial. That is called a contested divorce. Once you've filed your answer, you've retained an attorney will go to court on your behalf, and the attorney can determine or fight for you to make sure that you keep the assets that you believe to be your individual assets. Those are called personal assets. They're things that you could have brought to the marriage, and if you brought them to the marriage, they're not dividable no matter what the other person says, because that's considered separate property under Georgia law. Once you get to court, you can also, even though you've been served and you are the defendant, you can also fight for custody. So not because you're the defendant in a divorce proceeding mean you cannot get the house, you will not get the children, or you will not get child support. You could be the defendant and still end up with the house, still end up with primary custody of your children, and still end up with child support from the plaintiff who filed the divorce against you. Please make sure you're consulting with an attorney, once again, in your local state to make sure you understand the state law as it pertains to divorces and as it pertains to you being the defendant. Now, people have asked me in the past, is there an advantage to being the defendant or being the plaintiff in a divorce case? If you're the defendant, there is no real advantage for the plaintiff. However, there's something called, in psychology, primacy recency. And that means people remember the first thing they hear and the last thing they hear. So if I were to say as a defendant, you're at a disadvantage, the only disadvantage I would be able to say is because the plaintiff gets to go first. So they get to tell the court their side of the story first. And that sometimes might prejudice the judge against you before they hear your side of the case. And they also get to go last. Primacy means the first thing they hear. Recency means the last thing they hear. So most people remember the first thing they hear and the last thing they hear, and they forget most of the things that were said in the middle. So in your situation, if you're the defendant, that's the only disadvantage you may have, is based on the psychological makeup of humans, that people remember the first thing and the last thing. And if the plaintiff gets to speak first and the plaintiff gets to speak last, and you spoke in between that what you said, most courts may sometimes not recall all of it. It's not that judges are dummies or that they're not going to remember what your side of the case is or your facts, but I'm just trying to explain and answer the question, is there any advantage to being the plaintiff? The advantage is going to be I get to speak first and I get to speak last. Getting back to the issue of division of property. If there's property to be divided and you've had that property before you're married, the court's going to allow you to keep that property, or the court should allow you to keep that property. Now, if there's real property in terms of your home and the plaintiff says, although he owned that house before he bought it, he's the defendant, I want a portion of that house, they would have to prove that they contributed substantially to the value of that house. So say you had that house because it was gifted to you prior to your marriage, and the plaintiff in the case, because you're the defendant, puts $100,000 into that house to repair it. And now that house is fantastic, it's beautiful, and it's worth way more than it would have been worth when you first got it. You're the defendant. Then a judge might say, because the plaintiff put $100,000 into that house, and the house at the time that you got it was only worth $50,000, and the $100,000 that they put into the house causes the house now to be valued at $200,000. Some judges will say what is equitable is that they at least get some of the equity that's left into the house, or the value, 50% of the value that they put into the house. So keep that in mind if you're in the middle of a divorce or you've been served with a divorce and you're the defendant, that a house that you brought into the marriage may be divided by the court somewhat based on the contribution that was made by the plaintiff in that divorce proceeding. If the plaintiff made no contribution, then you can always go forward. Your attorney can argue it was separate property, it was obtained prior to the divorce, and you should get it. Not because you're the defendant. Once again, means that you're not going to get custody of those children. You could end up as a defendant if you file your answer. You can end up with primary home. You could end up with primary custody of the children. You could even end up with alimony if the plaintiff makes more money than you do. You could end up with a 50% portion of a business that you all have together, even if the plaintiff says, I want the business, and they're divorcing you. If you can prove adultery as the defendant, Georgia looks at division of property as it pertains to fault. So once again, defendant, if you were served with a divorce, don't get taken to the cleaners. Hire an attorney wherever you're located and have that attorney go to court and fight for you, fight for your rights to make sure that the property is equitably divided, and what is in the best interest of your children is exactly what is done. We thank you for watching The Legal Zone. Remember to subscribe and click the bell icon so that you'll be notified when we load additional videos in the future. I'm Marcia Mignot, and you're watching The Legal Zone.